can start. I'm going to let the law clerks in. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-3028 et al. United States of America versus Nizar Trabelsi, also known as Nizar Ben Abdelaziz Trabelsi, also known as Abu Kaka appellant. Ms. Getzel for the appellant, Mr. Smith for the appellate.
Good morning, Ms. Getzel. We'll hear from you.
Good morning, Judge Wilkins. May it please the court. Celia Getzel for appellant Nizar Trabelsi, and I'd like to reserve 2 minutes for rebuttal, please. Since the court heard this case in 2017, U.S. authorities have ignored the Kingdom of Belgium's official, united, uncontested position as relayed through its Ministry of Justice that counts 1 and 2 of the U.S. indictment may violate Article 5 of the treaty, and 2, regardless, under the terms of this bilateral treaty, under uncontested Belgian law and under Belgium's grant of extradition, specifically in this case, Mr. Trabelsi cannot be prosecuted for overt acts 23 through 26, specifically the conspiracy to bomb the Kleinbrugel base. U.S. prosecutors have portrayed for the lower courts and for this court a foreign separation of powers issue that simply does not exist in Belgium, and somehow convinced the lower courts to ignore Belgium's official interpretation of a bilateral treaty, completely disregard the ministry's official acts recognizing the supremacy of its judiciary.
Ms. Getzel, can you be clear about the separation of powers issue? What are you saying that the U.S. is ignoring? What is the separation of powers question that you're identifying?
So the U.S. has suggested that there is some sort of separation of powers issue in Belgium that the lower court should ignore, and that the U.S. courts should ignore. But what we're saying is there is no separation of powers issue. There is one united voice there.
And by separation of powers, I guess I'm just asking, you're saying the purported difference between the court's view and the ministry's view. Is that what you mean by separation of powers?
That's correct. The U.S. Government in this case has portrayed that the minister's view of the actual grant of extradition in this case is somehow different from the court's view of that grant of extradition. And that is simply not the case here.
Suppose we don't agree with you and we believe that the ministry does take a different view than the courts. Why shouldn't we view that the ministry's view, the executive's view, prevails?
The ministry has relayed the supremacy of the judiciary. So the ministry has adopted the judiciary's view in complying with the orders of—
You're fighting my hypothetical. My hypothetical is, suppose we disagree with that argument and we find that the ministry is basically conveying what the court told it to convey, but not necessarily what it believes the proper interpretation of the treaty is. What do we do then?
So two things. One, that is the interpretation of the treaty is separate from what the grant of extradition in this case permitted. So adherence to the executor of the arrest warrant. And the ministry has never said that the executor wasn't part of the grant of extradition in this case. Secondly, this sister court has spoken directly to it and said the District Court of Appeal for the District of Columbia interprets the ministerial order as authorizing extradition without the limits set during the executor of the arrest warrant. It doesn't say the ministry has interpreted its ministerial order as authorizing extradition without the limits set. It says that this court has misinterpreted and made a mistake about what it is that was actually granted when.
Ms. Getzel, how do you square that position with the Brussels Court of Appeals ruling in the context of the motion to enforce, in which it appears, and I'm looking at 2021, I believe, JA 2021, when it appears to recognize what this court has said and that there is some sort of distinction or conflict between what the court views and what the ministerial order says. I mean, it suggests very clearly that the DC Circuit has given priority to the ministerial order, and that its own decisions don't modify or cancel that order. So I'm not sure that I understand your view that there is a unified voice coming from Belgium as to what is happening here.
So, first of all, I think that this citation on 2021, the court is referring to Judge Moss's lower court decision here, not the DC Circuit's decision.
Except it says the DC Circuit in the very first sentence of the paragraph. The aforementioned American decisions, and in particular that of the DC Circuit, currently before appeal, right?
Yes. So what this is saying is that the courts recognize that there's a dissension, there's a difference in interpretation of how Article 5 of the treaty should be applied. So to the extent that there's a difference in decision of how the law is applied, that has been finally decided. That was finally decided in Belgium when the appeal was, the government's appeal of the August 2019 decision was dismissed. So as a legal matter, if the court here is looking to what is Belgian law, then it should look to the courts as to how to interpret Belgian law. If the court is looking to how to interpret the extradition treaty, the ministry has relayed through a March 5th note a very clear prescription that Mr. Trabelsi cannot be tried here for overt acts 23 through 26, and that the court should familiarize itself with the analysis in Belgium and at least consider that that is the law in Belgium.
Ms. Getzel, can I just ask you, you mentioned the dismissal of this decision, or where is that? Is that somewhere in the record?
So that is it's cited in a footnote in our briefs, and the government has recognized it as well. It's the Court of Cassation decision. It's the last decision in the appendix at page 2200. And that occurred on March 4th of 2021.
And are we just taking judicial notice of that, or is it somewhere in the record?
Yes, the court, it is in the appendix. We've cited it. It is a decision of a foreign court that the court can take judicial notice of. It actually found no legal basis for the government's appeal of the August 8th decision.
Ms. Getzel, if I could just ask you some questions about subject matter jurisdiction here for the court. Our court in 2017 didn't reach the question of remedies. What would be the appropriate remedy if you were to prevail? But I'm wondering if there were a violation of the treaty here, what the remedy would be. And it seems to me that the remedy in part may go to the question of subject matter jurisdiction, because it's unclear to me. I mean, if we can't if we can't dismiss the indictment, then how does Mr. Trabelsi have redressability for his claims? So I'm wondering if you could address that question.
So I'm a little unclear on your question. In terms of a remedy, we are asking the court at a minimum to order that overt acts 23 through 26 be stricken from the indictment, to give effect to the extradition order in this case, so that he is not tried for crimes that he was already tried for in violation of the treaty. The court can dismiss the indictment and can discharge Mr. Trabelsi under the Supreme Court case law about speciality in Johnson versus Brown.
Isn't speciality a different type of concept? So even under the text of this particular treaty, the prior prosecution limit in Article 5 seems to run to the extraditing state, to Belgium, right? Belgium has an obligation not to extradite someone in violation of Article 5. So once Mr. Trabelsi is extradited and he's now here in the United States, does he have an injury or a claim against the US government for a violation of Article 5? I mean, it doesn't seem that the United States is the cause of his harm in this instance, right? It's the Belgian government who has the treaty obligation. Whereas for speciality, the US government has an obligation. And those claims may well be cognizable. But it's not clear to me that he has a prior prosecution claim against the US government or a non-bis claim against the US government once he's already been extradited by Belgium.
So he does, because Article 5, both parties have contracted. And Article 5 applies to both parties. And the harm here that must be redressed, and the reason why this is here pre-trial, is because the harm is in him being tried for offenses for which he has already been tried. So this court can stop that harm, redress that harm, and stop the violation of Article 5, the violation of putting him in jeopardy twice for the same things that he was already tried for in Belgium by stopping this prosecution.
Ms. Getzel, can you cite, are there any cases in US courts in which such a claim has been successful? So where someone has already been extradited and there's a claim that they should not have been extradited under, a non-bis or prior prosecution type of treaty obligation? Because I was not able to find any such case, and I don't believe that Mr. Trabelsi cites any of those cases in his briefing. It seems that the nature of non-bis is that it runs against the extraditing state. And there are a number of cases that suggest that is how that principle is understood.
It runs for both countries in the treaty, as written in the treaty. So extradition shall not be granted when the person sought has been found guilty, convicted, or acquitted in the requested state for the offense for which extradition is
Sure, both countries have an obligation not to extradite people in violation of this principle. So if someone were in the United States and Belgium was seeking extradition to Belgium, the United States would have an obligation not to violate Article 5, and a person about to be extradited perhaps would have the ability to challenge their extradition under Article 5 before they were extradited. But it seems that this language, I think, pretty clearly runs against the extraditing, the state that's been requested to extradite. Extradition shall not be granted.
Well, here, the state that extradited Mr. Trabelsi is telling US authorities, whoops, like maybe we shouldn't have extradited him.
Well, I want to follow up on that point, which is a sort of an extension of what Judge Rao just mentioned, which is, why is it then that we should now care about or give effect to a change? So assuming that at the time the order was originally issued, it was clear and there was dissension between the Ministry of Justice and the courts regarding whether or not this person should be extradited. We get the order, the person is extradited. under what circumstance can the ministry then change its mind about the extradition and have us give that effect in terms of striking the provisions or whatnot, the remedy that you want us to apply? Why should we do that? I mean, in general, we believe in finality of rulings, that new law doesn't necessarily redound to the benefit of a person who was previously considered under it. So I'm just not sure why it matters that they've now changed their mind, according to you.
So the ministry, our position is not that the ministry has changed its mind. It hasn't changed its mind. Our position is that, and it's pretty ambiguous, the extradition order is ambiguous. Belgium clearly thought, and that's apparent from this new decision, that it was limiting the grant of extradition to exclude these acts that he had already been tried for in Belgium. And the extradition order was somewhat ambiguous. It said that he was being extradited pursuant to the exequatur, pursuant.
Okay, can I ask you, if the order is ambiguous, I'm not sure it necessarily means that we ask the court for the answer, right? I mean, you can imagine a world in which because this is a political process, I think you would concede that, there seemed like there could be a number of options for construing an ambiguous extradition order, one of which is we turn to the diplomats and we say, can you please go ask the ministry what this means, since it isn't clear. One, I think, could be figuring out what Belgian courts actually do in terms of their construction of ambiguous law. So if we were to, apply Belgian law, like what is their rule of construction when they confront ambiguous text? Or we could apply our own rules of construction as to how we address, which I think is somewhat what Judge Moss did in this case. We look at the text, is it clear or whatnot, right? So why are you suggesting we do get a fourth option, which is just ask the Belgian courts how they would interpret this particular provision?
So we're not saying that the treaty provision is ambiguous. We're saying that the extradition order, the fact of the grant of extradition, so the 2011 ministerial order may have been, and maybe it might have even been purposefully ambiguous, but now we have a final interpretation of of the scope of the grant of extradition under the ministerial order.
And that's coming from the courts or from the ministry?
It is coming from both. I mean, the March 5th note and all of the Belgian state's pleadings in Belgium make clear that its judiciary is supreme, that it might have taken a different position in litigation, which happens here all the time when the DOJ takes a different position in litigation.
What about the position it took in the actual diplomatic notes that it sent when it was clarifying what the order meant? That's not in litigation. It sent a note, didn't it? The ministry.
The ministry, the note that it sent in 2019, in November of 2019, it has explained in official statements, was simply meant to convey that it had appealed the interpretation of article, that it had appealed the August 2019 decision and differs in its interpretation of whether an offense-based or fact-based analysis should apply to Article 5 of the treaty. But that's not what we're saying here. The minister never questioned that the grant of the court's final determination that the grant of extradition does not allow Mr. Trabelsi to be prosecuted here for overt acts 23 through 26.
Ms. Getzel, did the ministry ever explicitly state that in any communication to the United States, that those overt acts were excluded?
The ministry never explicitly stated that the overt acts were included. So the ministry said that those overt acts could be used as facts or evidence that that can be used as evidence to prove the charges in the United States. But the ministry has been ambiguous. It has never stated that he can be convicted here for the conspiracy to bomb Klein-Brogel.
Or that he can.
The problem that I have, though, with all of this is that, we heard this case in 2017. And it seems to me that a procedure whereby once the extradition is granted and the person is sent here, and the communications are made with the stipulations as to what the grounds will be for allowing the extradition, that should be the end of it. We're 4 years later, and here we are trying to, discern what these Belgian court decisions really mean, and whether there's a real dispute between the executive and the judiciary about what they meant with the extradition order. Why should we, at this point, why should we really do anything other than just follow the law of the case doctrine and say this has been decided?
It's truly extraordinary that your sister court, the Brussels Court of Appeals, has said to you, you misinterpreted the grant of extradition. You made a mistake the first time. That is significant and material cause to reopen the decision. But also, there is no dispute in Belgium that he cannot be convicted here, that at a minimum, overt acts 23 through 26 were excluded because the ministry never disavowed the exequatur, the order of enforcement in extraditing Mr. Trabelsi. And the law also in Belgium is finally decided, it is clear under Belgian law that Article 5 requires a fact-based analysis. It's 100% clear. There is no other interpretation that can be made. The minister has relayed the court's final decision. So to the extent that this court did not recognize that or fully consider the final law in Belgium when considering what deference it was giving to the Belgian extradition decision and in basically not engaging in an analysis of what Article 5 means, in deferring to what it thought was a reasonable interpretation, what the Belgian government has now told you is that that was not Belgian law. That was not a reasonable interpretation of the treaty under Belgian law. So,
Ms. Getzel, if I could ask you a related question, do you think that the Trabelsi decision in 2017 of this court, do you think that its jurisdictional holding is law of the case for us?
Yes.
Deciding this appeal?
Yes, there's been no question of jurisdiction in this case. Neither party has raised it, so it hasn't been.
Well, but jurisdiction is something we always have to consider to ensure that we have the authority to decide a case. But do you think that the previous panel's decision about jurisdiction is law of the case? I understand you don't think that the merits are law of the case, but do you think the jurisdictional holding is law of the case?
So we think the merits and the jurisdiction are law of the case, in the sense that the court said we defer to Belgium. There's a presumption that the extradition order was proper, unless there's some reason to rebut or think that it wasn't. Here, we have rebutted that presumption. So we're not challenging the law of the case. We are presenting facts that should alter the court's application of that law to the facts of this case. And in terms of jurisdiction, I mean, this is a double jeopardy issue. Mr. Trabelsi is here being tried for the same crimes that he was tried for in Belgium. The harm is the trial. We are pre-trial. And so jurisdiction is proper. And if the court has no further questions.
All right, we'll hear from, any further questions?
Yeah, thank you.
All right, we'll hear from the government. We'll give you a couple minutes on rebuttal.
Thank you very much, Your Honor. May it please the court, Peter Smith on behalf of the United States. This court already rejected appellant's challenge to his extradition, and there is no basis for upsetting the court's 2017 decision in this case. Appellant has a very high burden to meet under the law of the case doctrine. As appellant's counsel seem to recognize today, he has to show extraordinary circumstances. One example would be whether this court's opinion in 2017 were clearly erroneous, which it is not. This court held in 2017 that the extradition order itself was clear and that it clearly allowed appellant to be prosecuted on the US charges without limitation. The courts in Belgium have not withdrawn, retracted, or modified that order of extradition in any way. The treaty is unchanged. The offenses are unchanged. The diplomatic notes sent by the government of Belgium to the United States expressing the view that appellant could be tried on all of the United States charges have not been withdrawn or modified in any way. Appellant's argument basically hinges on pleadings internal to Belgium, which were never directed to the United States, and 2 notes from Belgian prosecutors conveying Belgian court decisions. Neither.
Can you speak to the exchange that Ms. Getzel and Judge Rao had about the nose bis principle running against the extraditing state? What is the United States government's view of extradition and the extent to which any potential mistakes about the extraditability, if that's a word, of the individual is something that can be remedied by this court?
Your Honor, as the government pointed out, there are principles of comedy. In its brief, the principles of comedy would be that this court would not second guess or look behind the extradition decision or the grant of extradition to see whether Belgium violated its own laws, for example, or whether Belgium properly applied its laws.
Well, what if assume in a hypothetical that the ministry and the courts now come running, the Belgian ministry, the Belgian courts, they've extradited this person with the order that we have, and we receive a diplomatic note signed by the minister and the head of the judicial officer that says we were wrong, so sorry. We don't think this person can be either extradited or that these charges can go forward. Is that something that, how do we account for that, or could we account for that?
That would certainly be a harder case than the facts of this case. And one could take the position that there would be no change, meaning that once extradited, the Belgian government couldn't somehow undo its extradition. But in the hypothetical, I understand the Belgian executive branch, the Ministry of Justice, to be saying, there was some error, there was some infirmity in extradition, which I guess would make it a harder case. The government hasn't argued that.
Would it make it a non-justiciable case? Judge Rao suggests that at that point, there's no remedy. If extradition is done and it's over, there's no redressability.
I think there is support for that view. The government didn't expressly argue that in its pleadings in this case. The government seemed to think that appellant would have some sort of recourse under the treaty, but he isn't entitled to dismissal of the indictment. And he, the court's question is a hypothetical. It is not this case. What happened in this case is not that the executive branch has somehow tried to undo the extradition.
So, Mr. Smith, in the facts of this case, if dismissal is not a remedy, what's the, how are his claims redressable? Is there any redressability for Mr. Trabelsi?
I mean, one could take a strong position and say that under Casey and those sorts of authority that he doesn't, and the government didn't argue that in that way.
I understand the government didn't argue it, but we do have an independent obligation to determine our jurisdiction. So
I guess I had always assumed that the court would, in applying the bilateral treaty, which is also the law of the United States, the treaty itself, that in applying the law, the treaty, that it would be able to reach the question of whether some acts were excluded, but that we didn't brief it that way. We didn't argue it that way. So I'm just sort of speaking off the top of my head. I don't.
Well, are you?
But I think to answer Judge Rao's question, the government, if this were just a U.S. prosecution that didn't have anything to do with extradition, and the government filed the same indictment, and the district court judge said, I'm going to strike overt acts, 23 through 26, because I don't believe that they are part of this same conspiracy. So I'm going to strike those acts from the indictment. Under 3731, you could appeal that, and we'd have jurisdiction over that interlocutory appeal, wouldn't we?
Yes, that would be right. I think so.
And is that essentially the same as what Trabelsi is saying here, or the relief that he is asking for here?
I mean, you're saying by analogy that if it were a U.S. case, right, he'd be able to obtain that relief. And I think we've always understood that to be the case. That's the way we briefed this case so far, that any relief he could get could be limited to striking those acts, but he can't get dismissal of the indictment. I think that was our position in our briefs.
But
not because it's not a remedy you're saying because he's not entitled to it under these circumstances, not because that's not something the court doesn't have the power to order.
I think that's right. Although I think we also argued that dismissal of the indictment wasn't a remedy the court could grant for the harm he was alleging, which is a violation of the treaty in this particular way.
But I mean, the government can take an interlocutory appeal under very limited circumstances, but one of them is if evidence is excluded. So if there's a criminal trial and the district court judge says, I'm not going to allow introduction of evidence concerning X, if it's important enough to the government and they believe that it's going to place their ability to obtain a conviction in jeopardy, it can take an interlocutory appeal of that ruling, excluding evidence, and we have jurisdiction to hear that, right?
You would, and I guess where this case differs is that appellants' rights here are limited to the bilateral treaty between the United States and Belgium. And although it's akin to a double jeopardy claim, it's not a double jeopardy claim under the US Constitution. It's a treaty-based claim, and the Belgian government is a separate sovereign. So there's no real double jeopardy bar. The relief that appellant could obtain runs solely from the treaty.
Which is so I mean, I agree with Judge Wilkins that an interlocutory appeal here, we may well have jurisdiction for that, but the question is whether Mr. Trabelsi has an injury that's cognizable under the treaty. As you say, the only basis for his claim at this point is his treaty rights. And I'm not sure how Article 5 runs against the US government. It may run against the Belgian government as the extraditing state. But I'm not sure how Article 5 runs against the US government, and I'm not sure how the US government would have caused his harm under Article 5, which he claims is, being unlawfully extradited by Belgium. So perhaps you could speak to that.
Yeah, I mean, I take the court's point, and it's certainly a reasonable position, and I understand the court's focus on the granting of extradition on the requested state, which is Belgium. But I was simply saying the government didn't make that argument in its briefs.
Mr. Smith, isn't the answer that to the extent that an extradition occurs pursuant to certain conditions that are noted by the requested state, they say we're allowing this extradition, but in many cases, not in toto, right? You can't execute him, for example, I think was one of the conditions in this very case, right? So that to the extent then that the receiving state violates that condition, I'm wondering whether the person isn't injured and has a cognizable injury, as Judge Rao points out, under the treaty, insofar as the extradition order, which was issued under the treaty, has specific conditions that the receiving state is violating. So if we had, for example, in this case, a very clear extradition order that says you cannot prosecute him for offenses 23, 24 through 26, or whatever it is, and that everybody was in agreement, the minister spelled it out very clearly, and the United States proceeded to do so, I don't know whether we would say that is not a cognizable injury from the point of the United States for a person trying to bring a claim in this court. They could say, under the treaty, these are the conditions, they're being violated, they run to the original state. However, you are a party to that treaty and you agreed upon accepting his extradition not to proceed in a certain way. Am I right about that?
Yes, and the short answer to your question, Your Honor, is that would be a different kind of claim. That would be a specialty claim where the argument would be that the prosecution somehow extended beyond the grant of extradition. Specialty is a doctrine that is not subject to interlocutory appeal, and this is explained in the government's brief. So appellant's interlocutory appeal, which is this appeal, is limited to Article 5 of the treaty, his double jeopardy type claim. So in the court's question or hypothetical where where the US government was somehow not complying with the grant of extradition, that would be a specialty claim. Like, for example, we filed charges and sought appellant's execution in the court's example, or we filed new charges that weren't covered in the extradition order. Those would be specialty claims.
I see, but we would ultimately have jurisdiction if the prosecution occurred and he was convicted or not, then he could bring it. It's just a matter of interlocutory versus later. It's not
right. That
would never be.
That would be part of his direct. Exactly. That would be part of his direct appeal. He could say, hey, they charged me. They said they were charging me with conspiracy, but they also added these 5 other counts that weren't conspiracy. And so that would be part of his direct appeal following his conviction.
And there are lots of cases adjudicating those types of specialty claims under treaties. Are you aware of any case where someone has successfully brought a prior prosecution or non-bis claim after being extradited to the United States?
I'm not, Your Honor, and the government's brief says expressly that at least framed narrowly in the way that appellant is raising this claim, we were not able to find any such case.
I was not able to find any such case either.
If the court has no further questions, I would urge the court to affirm the judgment of the district court. Thank you very much.
All right, I think you were out of time, but we'll give you 2 minutes.
Thank you. There may be no such case because normally countries don't prosecute people for the same thing twice. So double jeopardy has not really been an issue. None of the cases that are referring to speciality claims, they're also sort of entwined with these claims of dual criminality. Here, the exclusion on extradition was specifically grounded in Article 5 of the treaty. It's a double jeopardy claim. The reason that the Kingdom of Belgium granted his extradition, not for everything, allowed him to be extradited here, but excluded over Acts 23 through 26 are because charging him and convicting him and trying him for those overt acts violate Article 5 of the treaty. And so that is the right that Mr. Trabelsi is seeking to vindicate. In addition, I just want to note that, this is a domestic criminal prosecution, and the right under the treaty is the right not to be tried, the double jeopardy right that both parties to a bilateral treaty have agreed upon is Mr. Trabelsi's, and Supreme Court case law is clear on that under Rauscher, that the right inheres to the person who is a beneficiary of the treaty, and that the treaty is our law. So all we are doing is asking this court to enforce the grant of extradition and the treaty, and to enforce Mr. Trabelsi's right not to be tried twice for the same thing. We ask the court to, at a minimum, order that overt acts 23 through 26 be stricken from the indictment.
Thank you. We'll take the matter under advisement.
Case number 20-1489, Oglala Sioux Tribe and Aligning for Responsible Mining petitioner versus U.S. Nuclear Regulatory Commission and United States of America. Mr. Parsons for the petitioner, Mr. Adler for the respondent, Mr. Bexley for the intervener.
Thank you. May it please the court. My name is Jeff Parsons on behalf of petitioners Oglala Sioux Tribe and Aligning for Responsible Mining. This case at base is about the significant cultural resources, including burials, prayer sites, and habitation sites, in addition to important regional groundwater aquifers that are at risk from significant impacts as a result of the Nuclear Regulatory Commission's failure in this case to follow the procedural requirements of the National Environmental Policy Act, NEPA, and the National Historic Preservation Act. With respect to the National Environmental Policy Act, the process the Nuclear Regulatory Commission used violated NEPA in at least three ways I'd like to highlight. The first is that the agency prepared and finalized their environmental impact statement in a closed adjudicatory proceeding without involving the public or other agencies as required for a lawful NEPA process. The second NEPA violation derives from revisions that the agency attempted here, particularly an analysis of the purported unavailability of cultural resources information that did not comply with the explicit requirements of the CEQ, Council on Environmental Quality regulation.
Mr. Parsons, you were, I guess, assuming that those regulations apply. And there's an argument that has been made in this case that they don't. So can you speak to that?
There has been an argument to that effect, Your Honor. And there are several cases that address that. I think that a good starting point for that is the Council on Environmental Quality regulation at 40 CFR 1500.3, which specifically says that these regulations are applicable to all federal agencies. There is a narrow exception or exemption contained in 1500.3A, which allows an agency to escape or sort of not comply strictly with the CEQ regulations to the extent that it's inconsistent with their statutory obligations or statutory requirements.
All right, but I don't think we have a concession here that they didn't comply. So let's assume they did. Didn't the commission find that whether or not they apply, they had done enough, the board, in having an evidentiary hearing, in fleshing out the unavailability finding in that respect? And don't we have case law that indicates that a hearing can sometimes suffice?
There is case law that says a hearing can sometimes suffice, but those cases are extremely limited to situations where the information is already included, has already been done. That was an example in the Natural Resources Defense Council case. The court discusses that and indicates that I think in that case, the court certainly expressed some cynicism, some doubt that that kind of process is lawful or wise. But in that case, the court found that sending it back, a remand in that case would have been utterly futile, I think is.
All right, well, what would a remand do in this case? I mean, I understood that the unavailability finding related primarily to alleged recalcitrance by the tribe. The information was all about, or the problem allegedly was the tribe's refusal to adhere to its original agreement concerning the survey and the process, the methodology. So if that's the case, I'm not sure what sending it back for some sort of a supplement or whatnot is going to accomplish. The hearing was held in public. All of those issues were aired. And so why would we remand? Why wouldn't it be futile under these circumstances?
Thank you, Your Honor. Obviously, the tribe disputes some of those characterizations made by the agency with respect to the tribe not staying true to its commitments throughout. The tribe throughout this process has been ready, willing, and able to aid and participate in the survey work. But that's the fact, is that there has been no survey of cultural resources at this site, no competent cultural resources survey. That was the finding, the adjudicated finding of the Atomic Safety and Licensing Board in 2015, affirmed by the commission in 2016. What the agency did was come back and propose different survey methods. The tribe participated the whole time. Repeatedly, the Nuclear Regulatory Commission staff unilaterally withdrew from those discussions and those processes because effectively the tribe was not in a position to fund the process. The record shows that the agency placed the burden of complying with the law on the tribe. And the tribe was not willing or able to fund the entire survey effort. As far as what could be accomplished on remand is exactly that, the survey ought to be accomplished.
No, I'm talking about for the violation that relates to the CEQ, alleged CEQ regulations violation, right?
Right. So that regulation at the time, it's gone through some changes, but the same language appears, was 40 CFR 1502.22. And that requires the agency in an environmental impact statement to do four things. Have a statement of the unavailability, a statement of the relevance of the incomplete information, a summary of existing credible evidence, So that never occurred. There was never a summary of what exists out there. The tribe brought forth affidavits and other examples of existing available information that the Nuclear Regulatory Commission staff never investigated, never asked, never looked into. Fourth, and importantly, is that the 150222 requires that the agency in that same process of the 150222 exemption or unavailability finding, that it evaluate the impacts based on theoretical approaches or research methods accepted in the scientific community. So even where there is an unavailability finding, it still requires the agency to conduct an analysis based on the information it has, theoretical approaches, and research methods accepted in the scientific community.
Mr. Parsons,
none of that occurred.
Mr. Parsons, if we assume for a moment that we agreed with the NRC that the CEQ regulations are not binding on the Nuclear Regulatory Commission, in that instance, what would be your argument under NEPA or the NRC regulations themselves? I mean, does your claim wholly depend on the CEQ regulations binding the NRC?
No. So if you start with the statute, the National Environmental Policy Act, as interpreted by this court in Public Employees for Environmental Responsibility versus Hopper, that's 827 F3rd 1077 at 1081 to 1082, it talks about the statute requiring, in the language of the court, the principal way the government informs the public of its decision-making is by publishing environmental impact statements, 42 USC 43322C. Agencies must prepare and make publicly available these statements. Now that's reflected in the commission's own regulations at 10 CFR 51.73 and 10 CFR 51.74.
But your claims are not that there wasn't an environmental impact statement. It's more about how they should have been amended and updated and further specified. I mean, are those requirements from the statute or the NRC regs? Is there support for that? Because NEPA is pretty, NEPA doesn't provide very much guidance at all about how precisely its mandates are to be implemented.
That's true. What it does require is robust public involvement. And what you have in this case is, instead of a publication of an environmental impact statement, including this unavailability determination or any analysis of cultural resources, you have essentially briefing to an administrative adjudicatory body in a closed process. The public was not allowed to participate in this process. In order to have been involved, parties would have had to petition, as the tribe did, to intervene over 10 years ago and meet what Commissioner Barron in his dissent on the commission ruling indicates or describes as a strict and fairly restrictive process for getting involved. And so there was never an environmental impact statement that included this information. It was only in the briefing of the agency sent to that administrative body. So there was no opportunity for the public to supply comments, no opportunity for the other agencies, state or federal, to review and deal with that as required, again, by the NRC's own regulations at 10 CFR 51.73 and 51.74 requires that other federal agencies, other state agencies, Indian tribes, the public have opportunity to provide those comments. And that's essentially the purpose of NEPA, is this cross-pollination, this idea that you put this information out to the public so that the agency can be well informed and perform what's the hallmark of NEPA, which is that hard look analysis, which
I
did
guess,
not
Mr.
occur.
Parsons, what I'm trying to assess is the extent to which the tribe's alleged recalcitrance to participate in the process that they insisted happen over a period of years. Why doesn't that provide important context for us in evaluating whether or not the agency has satisfied its NEPA obligations. So, I understand that ordinarily we would be in a world in which the agency has the obligation to determine cultural resources. It has to go out on its own and look for the information. And if it can't find it, then perhaps per the regulations that you point to, the CEQ regulations or other regulations, they might have to make certain statements. But that's in the sort of ideal world where we haven't had prolonged engagement with a tribe that says the way in which you do this is you have to have an interview with the elders, you have to, engage us in a certain way, et cetera, and then changed its mind about it and made it difficult to follow that process. Why can't and why shouldn't the court take into account what actually happened here when deciding whether the hearing where all of the unavailability was fleshed out and deciding whether or not that was sufficient to satisfy any duty regarding cultural resources in this case?
Yeah, thank you, Your Honor. I think the record reflects that the tribe was engaged and cooperative. And it was the Nuclear Regulatory Commission staff, in fact, that repeatedly pulled the plug, so to speak. For instance, if you look at the sort of the last interaction between the parties in February, March of 2019, what you end up with is a example where the tribe brought together all of its leaders, including leaders of other tribes, and had a meeting with the Nuclear Regulatory Commission staff and its consultant. And everyone agreed at that meeting that things would go forward and this was going to be a productive relationship, and we would put together this methodology that NRC staff never actually put together. Literally a week later, on March 1st, 2019, NRC staff sends a letter saying, we're done with this. We're not going to go forward with those processes. This is at those letters you can find at Joint Appendix 1888 is the NRC's.
Sorry, go ahead and give us the sites. 1888.
And then the tribe's letter is at JA 1857. And
so
I think,
do you dispute that prior to that, the NRC staff had provided a proposal for methodology and the tribe at one point had agreed to it?
the tribe had agreed to a process. There was never a methodology put forward on the table. That's the problem, is that the NRC said that here's the process we're going to follow. And as a component of that, the tribe and the NRC staff and its consultants will develop a methodology for the site survey. And the problem came when the Nuclear Regulatory Commission staff failed to provide any methodology for the tribe to review or assess. What it did was relied on the tribe both to provide the methodology as well as—
Can you define methodology as you're using it in this?
Sure.
Way? What do you mean?
I'm talking about the actual process by which the people would walk the site and figure out what kinds of cultural resources are on there, what kind of transects you'd use, how far apart people would be, how many days you would go, what kind of area you would review. Once you acquire that information, what would be the process by which the tribe and interested parties and the commission staff and its consultants would review and analyze that information.
I thought the methodology was supposed to be generated by the contractor in consultation with the tribes. I thought that was one of the 5 prongs of the original March proposal that the tribe agreed to. This is a very fact-specific case, so I may have gotten it wrong, but I thought there was a proposal that had 5 steps to it or pieces to it, including the hiring of a contractor, and that the contractor was supposed to propose the methodology. the tribe agreed, and there was per diem or whatnot for a certain number of tribe people to be involved, and it was all basically put together, and then the tribe pulled out. Am I wrong about that?
I think you are wrong about that.
Okay.
The NRC staff consultant never put together that methodology. In fact, the methodology that they had suggested in 2018 was what would be called an open site approach, which was not a methodology. It was a sort of, you all go out there and see what you can find and then let us know. And the tribe had informed NRC from the very beginning that that was unacceptable. And that's what led to the original adjudication finding that there was a violation of both NHPA and the National Environmental Policy Act. So the tribe was prepared and working with the consultant, the NRC staff consultant, to prepare that methodology, to work on that. And that's when the Nuclear Regulatory Commission staff on March 1st, 2019, unilaterally withdrew entirely from the process and decided it would rather litigate instead of do the work on the ground. And unfortunately, what you mentioned as the per diem and the cost, that was associated with what the record reflects as an honorarium, a $10,000 honorarium to the tribe. And that was supposed to, in the agency's view, compensate for all the effort the tribe was supposed to put forward. But what came out eventually, or ultimately, was that the NRC staff was relying on the tribe and its personnel to actually conduct the site-specific pedestrian, that is, walking survey of the site. And in the Atomic Safety and Licensing Board hearing, the math was done during the hearing, and even the most basic survey of a site like that would require minimum $30,000.
Parsons, if I go back and I read the board's decision coming out of the hearing, am I going to see a different story about who's responsible for the unavailability? And if so, doesn't the board's version get some deference from the court as long as there's substantial evidence in the record to support what the board concluded the facts are about how this thing transpired? Don't we have to give that deference?
Well, I think what you'll find in the record is the board was equivocal on and did not want to assign blame, and in fact said it's not clear who did what or who is to blame for this. The fact is the survey never got done, and now the Nuclear Regulatory Commission staff wants to come in and try to assert unavailability of information relying on the CEQ regulation at 40 CFR 1502.22. So that was the basis of the last hearing in the case. And as we argue, doing that process is not an environmental impact statement. It's a closed adjudicatory hearing where the public was excluded entirely. If you look at the summary disposition ruling that the Atomic Safety and Licensing Board made on the National Historic Preservation Act issues, the board found that the NRC staff had complied at a bare minimum with the National Historic Preservation Act consultation requirements. And that was based literally on one introductory face-to-face meeting and 2 exchanges of letters, none of which were substantive. And if you look at the requirements of the National Historic Preservation Act, they're very clear that the meaningful and good faith consultation must be for identification, evaluation, and mitigation of impacts for cultural resources.
Mr. Parsons, you're over your time.
Thank you, Your Honor.
So if you want to take a minute to wrap up or give an overview of any other issues, please do so, or you can just rest on the briefs and the rest of your.
I think the papers are pretty well. I will just note that what you find in this case repeatedly is instead of conducting the required analysis under the National Environmental Policy Act or the National Historic Preservation Act, what the board, the Atomic Safety Licensing Board, affirmed by the commission, did was essentially add conditions to the license. Whenever there was a problem they couldn't resolve or an issue that wasn't analyzed, what they would do is add a condition to the license. They did that with respect to cultural resources, saying we'll place a monitor for construction. No input from the tribe, no consultation on that mitigation requirement. With respect to the boreholes, the thousands of abandoned, unidentified boreholes at the site, they did the same thing. Here's a license condition saying the company should make its best efforts to find those boreholes. No analysis of that or how they're going to do that or what the impacts might be. With respect to the transportation and disposal of radioactive waste, that was not analyzed in any depth in any NEPA document.
It actually was in the EIS, Mr. Parsons. I mean, I found places where they talk about waste disposal. So it seems odd that you would argue that it wasn't addressed.
What they did is relied on the generic environmental impact statement, which talked about a generic route through the southern half of the United States. What you have in this case is a specific proposal to dispose of the radioactive waste in White Mesa, Utah, which would require a much different transportation route across high Rocky Mountain passes that was not addressed, and nor was the disposal or the issues at White Mesa discussed in any way, shape, or form in the EIS. It was relying entirely on the generic
Parsons, do you have any actual record evidence that links the substantive changes in the license to the procedural deficiencies that you say occur here? I understand your argument, which is every time we see a license provision being added, we think that's because they didn't do enough in the EIS. But is there something that expressly makes that connection in the record?
Well, those conditions were added in the board rulings and the commission rulings where they identify, yes, this is a gap, and so we're going to add these conditions as a result of those.
I mean, they don't say here we know that NEPA requires us to say or evaluate a certain condition or a certain impact, and instead of doing that, we are going to add a condition. I didn't see that anywhere in the record.
So that's how the borehole condition arose. That's effectively how the tribe cultural resource monitoring condition arose. If you look at the last ruling of the Atomic Safety Licensing Board, they find that the programmatic agreement doesn't provide effective mitigation, and thus they will add that condition. And unfortunately, at the end of the process, adding conditions that attempt to resolve those gaps doesn't provide the National Environmental Policy Act process, does not provide the tribe with the required National Historic Preservation Act consultation. The NHPA specifically requires meaningful and good faith consultation on things like mitigation of impacts. And by adding a condition at the last minute with no opportunity for comment or review by the tribe.
Of course, I'm really worried about the implications of your argument in this regard, because it seems that you would be disincentivizing agencies from actually making licensing provisions that would be beneficial to the environment or to your clients or to whatever. It's an odd argument to suggest that because in the license, they've decided to have a monitor, for example, to mitigate against any future impacts in an environmental setting, that just because they've done that, it somehow means that they didn't do sufficient work up front pre-license per NEPA.
I don't think that's what we're arguing. Of course, any license condition that would be beneficial to the tribe's interests or the protection of the environment, I think would be welcome. The problem is the NEPA process is such that these draft environmental impact statements, all this information was provided to the agency in comments on the draft environmental impact statement. There's nothing new that arose. And so all these issues were in front of the agency. So they went through the draft environmental impact process decided not to include any of that, decided to finalize that impact statement, and then go to litigation in front of the board on what they thought, the staff thought was a legally compliant environmental impact statement. The board found that it was not legally compliant. And instead of sending it back for the public review process that NEPA requires, they simply tack on these conditions. And so it's not that the conditions shouldn't be considered. It's that the National Environmental Policy Act and the National Historic Preservation Act provide these processes that are necessary to comply with the law. And they're right out of the statute. In NEPA 42 USC 43322C, it says the EIS issues must be prepared before taking any federal agency action. That means before the license is issued, these things have to be addressed. Similarly, in the National Historic Preservation Act at 54 USC 306108, it talks about prior to the issuance of any license, the agency must take into account the effect on cultural resources of any undertaking. So the statute, Congress mandates that the agency do these processes in a certain way that.
And your argument is that they're adding the licensing provisions, which, by the way, indicates that they were cognizant of these issues because they added a license provision. So, but you're suggesting that that is not compliant with NEPA, even though you said they had the information before them in the draft process, which I think is the purpose of NEPA, right? To make sure that they're considering things. So they had it. They may not have put it into the final EIS, but they made it into a licensing provision. And you say there's a NEPA violation as a result?
Yes, by adding those conditions without any public review, without allowing any other agencies or the tribe to comment or give input, it violates both the National Historic Preservation Act with respect to the cultural resources, as well as the National Environmental Policy Act.
All right. Any
Thank
further questions, Judge Rao, Judge Jackson? All right, thank you. We'll give you a couple minutes on rebuttal, Mr. Parsons.
Thank you.
We'll hear from Mr. Adler.
Thank you, Your Honors. May it please the court. My name is James Adler. I represent the Nuclear Regulatory Commission in the United States. The Oglala Sioux tribe and other interveners in this case filed numerous adjudicatory contentions through the NRC's adjudicatory hearing process, which produced a number of board and commission decisions, as some of Your Honor's questions have recognized. All of the issues petitioners raised in their briefs were dispositioned through these hearing decisions. But petitioners' briefs, and really again, the petitioners here at argument, largely ignore what the board and commission actually said in these decisions. And petitioners also largely have ignored the underlying record documents that the board and the commission relied on in making these decisions. Petitioners instead proceed essentially as if the NRC, through this extensive decade-long hearing process, never spoke to any of these issues. The NRC's hearing decisions, as our brief discusses, reasonably disposition these various contentions that are the subject of this court case. Because petitioners fail to grapple with the NRC's reasoning and the underlying record support for it in any meaningful way, this court should deny the petition for review.
Can you just address for me, if we were to find that 40 CFR 1502.21, the CEQ regulation, is applicable here, do you agree that with the petitioner's contention that it was not, that regulation was not complied with in this instance?
No, Your Honor. The finding in the hearing process was that whether or not it applies, I think the NRC's position is it's not legally binding, but even if it were, the NRC complied with it through the adjudicatory record developed in the hearing process, consistent with court decisions. And I think the licensing board went through the various criteria of that CEQ regulation, found that they'd been complied with, and didn't see a need to require an essentially redundant EIS supplement to say, here's what the hearing process already said and all these publicly available hearing decisions. Further, there's no.
But I guess that begs the question of, so you're saying that you understand it's not literal compliance, but the non-compliance wasn't prejudicial error, seems to be what your position is.
Your Honor, I think there are two things. The first is the judicial acceptance thus far of the NRC's approach of using this public hearing process in appropriate situations to supplement the EIS. And here there was no additional cultural resource information to report in a supplement to the already completed EIS. So this would have been a supplement explaining why there's no environmental impact information, which isn't something that trips the judicial standard for requiring a supplement under NEPA, which is new and significant environmental impact information that paints a seriously different picture of the environmental landscape. Here it's the same picture. There's just some additional hearing decisions that are already publicly available that provide more information on why no additional environmental impact information.
But the regulation has more specifics to it than that, right? It's not just, I understand if the regulation that Judge Wilkins was asking about was just the part about explain why this information is not available. But it seems to me that 40 CFR 1502.22V1 has some pretty detailed requirements for what the agency is supposed to say. So is it your position that the record of the hearing evaluated the impacts of based on theoretical approaches or research methods generally accepted in the scientific community? That's one of the prongs here.
Your Honor, I think the licensing board's 2019 decision went through these issues in the most detail. I think this has to be understood in the context of the information the NRC was trying to gather, which was information that really only the Oglala Sioux tribe can provide, which is the Oglala Sioux tribe's views on whether there are any features at the site or any properties at the site that are of cultural importance to the Oglala Sioux tribe. And the Oglala Sioux tribe's position aggressively throughout the proceeding was that only the Oglala Sioux tribe can provide this information. The board discusses this several times in its decisions. And so, the fact that the NRC tried several times to get this information from the Oglala Sioux tribe, to arrange surveys so that the Oglala Sioux tribe would have representatives out at the site to provide input, and they didn't. This is the context in which we're operating here. I don't think there's scientific methodologies and things like that to investigate here. Yes.
Rather, to that point, after the survey didn't take place, why did the commission not conduct oral interviews with the tribe about the cultural resources? Isn't that a step that the commission could have taken even without the surveys, or should have arguably taken?
Your Honor, and the commission discussed this in its 20-9 decision a bit. The interviews, I think, it seemed like the petitioners are arguing that the NRC should have just gone out and conducted these oral interviews, but that would go outside of the usual government to government consultation approach used in this cultural resource context. And the tribe had been pushing all along for the NRC to ensure that consultations were on a government to government basis. So the idea that the NRC would just go out and directly interview tribe members, not through the Oglala Sioux tribe, it just wasn't consistent with anything that had been contemplated in the proceeding to that point. And I think the methods, excuse me.
Sorry, go ahead.
A bit more about that in terms of the government. So you think the individual oral interviews would be inconsistent with a government to government approach? What about the NRC's obligation to satisfy NEPA and the NHPA?
Right. Well, The oral interviews, I think, were considered as part of the overall approach that would involve a survey and oral interviews to provide additional information on properties identified through the survey. I don't think they were contemplated by the NRC at any point as just a standalone activity that wouldn't be related to the survey. So this would have been a very, significant change in addition to, seemingly being outside of the government to government process, because this was not something that the Oglala Sioux tribe had arranged. This was something the Oglala Sioux tribe said, hey, you didn't do this, you could have done this, but it was always contemplated as part of the, some agreed upon survey approach and as a component to inform the results of that survey.
Mr. Adler, can you speak to Mr. Parsons' characterization of why the negotiations broke down? He suggested that it was really the staff that gave up on the process.
Your Honor, in the staff's determination and when it decided to cease negotiations, it was based on the clear, wide, and even expanding gulf between the parties, and the fact that now, many years into this process of consulting with tribes, and then the additional years of focused consultation with the Oglala Sioux tribe, things didn't seem to be getting towards any sort of actual survey being conducted. In 2018, the Oglala Sioux tribe had the licensing board and the staff convinced that the Oglala Sioux tribe was fine with the so-called March 2018 approach that the NRC staff, working with a contractor, had developed. This is at JA 1840 in the Joint Appendix. And then this was in the spring and the winter and spring in 2018. Then in June, the tribe called a halt to the survey as it was getting in motion, said, we want to hold a meeting instead. And the NRC staff complied, put off starting the survey, went to the meeting. And at that meeting, the tribe presented this quality services contractor proposal that the tribe had obtained that would have involved many more people, much more time to survey the site, a much larger geographical area to survey, would have cost in the neighborhood of $2 million, and then said, all right, now NRC staff, your job is to take this new proposal we've just given you at the 11th hour right before our survey and figure out a way to fit this into whatever you think is a reasonable budget. And the NRC staff, I think, very reasonably did not know what to do with that. And then a similar cycle, not quite the same, but repeated in 2019, when the NRC staff's contractor developed a methodology referred to as the February 19th or 2019 methodology. This is a Joint Appendix 1864 to 1887, which the petitioners say was not a methodology, but it was a draft methodology with room for the tribe to provide input to the extent that it wanted to, as well as for other Sioux tribes that were participating at the tribe's request in this process to provide input. And at a meeting to discuss this, as the board chronicled in its 2019 LBP 19-10 decision, the response to this methodology was essentially, you need to redraft this whole thing, and here are things we want in it, which sounded very much like the $2 million quality services proposal that
All
had
right, so
several
Mr.
things
Adler,
in 2018.
we do have that LBP 1910. And I tried to ask Mr. Parsons whether or not the story that he was telling about who was responsible for the unavailability was something that he was gleaning from the various records, or whether the board sort of set it up that way. I hear you suggesting, and I see, for example, on JA 897, that there is a recognition of the Oglala Sioux tribe's non-cooperation, and that is really the reason for the unavailability. Am I misreading this, or was there a commission finding, a board finding, that the tribe really was why we don't have this information?
I think it's two things. There is the finding you're discussing in that section B, the Oglala Sioux tribe non-cooperation being a reason for the information being unavailable. The other component was the board with the commission later affirming, finding that the NRC staff had proposed reasonable methods for obtaining this information through a survey, and the Oglala Sioux tribe had rejected those. So I think, absent, if the NRC staff had proposed nothing or its proposals had not been found reasonable, then we might be in a different place. But the board and the commission found that the NRC staff had made reasonable proposals to carry out what is the petitioners say is the NRC's responsibility to try to obtain this information. But those proposals were rejected. Your Honors, I see my time is up. If there are any specific issues you'd like me to address, I'm happy to.
Judge Rao, Judge Jackson. All right, thank you, counsel.
Thank you, Your Honor.
We'll hear from counsel for intervener.
Good morning, Your Honors. May it please the court. My name is Christopher Pugsley. I'm here on behalf of the intervener in this case and the current NRC licensee, PowerTech USA, Inc. While there have been a few other contentions raised on appeal by petitioners other than cultural resources, I think this court would benefit from a quick overview of how NRC conducts its licensing and regulatory oversight over ISR projects in situ recovery. First, the Atomic Energy Act and the Commission's implementing regulations dictate that a multi-tiered approach must apply to ISR, not can, but must. So first, you have to obtain a license. All that requires is an application that shows sufficient information to assess the ore body and the surrounding licensed site area to make sure that NRC's statutory mandate is satisfied, which is that the measures taken are adequately protective of public health and safety and the environment from potentially significant adverse impacts, as we discuss on page 10 of our brief. Once the license is issued, before the licensee can even start doing site-specific construction, they must demonstrate to NRC that they have obtained all other relevant permits. PowerTech is currently in possession of an underground injection control permit and an aquifer exemption under a statute the petitioners don't even bring into question, which is the Safe Drinking Water Act. And currently for the state of South Dakota, the U.S. Environmental Protection Agency retains jurisdiction to issue that, and that was issued, and it is now on appeal. But most importantly, with respect to groundwater, the aquifer exemption clear-cut objective definition in the statute is the water in the ore zone cannot now nor ever in the future serve as a source of public drinking water. PowerTech is also required to get 2 permits from the state of South Dakota, which we have not yet obtained. So truth be told, we can't do anything at the site right now anyway. After all the permits are obtained, the licensee is allowed to construct the site, but that's not the end of the regulatory oversight from NRC. NRC is responsible for these projects for conducting what is known as a pre-operational inspection. And this goes directly to the byproduct material issue petitioners raise, the groundwater issue that they raise, and the mitigation measures issue they raise. Because if the standard operating procedures prescribed by NRC for mitigation are not in place to NRC's standards, or if a byproduct material contract is not in place, or if PowerTech hasn't adequately defined what petitioners seem to think is termed baseline groundwater data, but it's not. The actual groundwater data has to establish what is known under 10 CFR Part 40 Appendix A, Criterion 5B5 of what's known as commission approved background. So because you cannot actually get commission approved background without installing a complete well field with a monitor well ring, because the monitor wells are designed to detect what are called excursions. And those are early warning systems that mobile constituents have released to the monitor well. And then at that point, you have to cease operations and bring back those constituents to NRC satisfaction.
So Mr. Pugsley, you seem to be talking about whether and to what extent any harms are actually going to occur. No construction is yet started, and here are all the other regulations that would control it. Do you have a view about whether or not the commission has violated the procedural regulations concerning the preparation of the environmental impact statement? Do you have any view on that part of this case?
Yes, Your Honor, I do. I believe that the NRC staff, through the concurrence of the licensing board and the commission, did satisfy both statutes. Most importantly, with respect to the National Historic Preservation Act, the statute basically says you are required to consult, but you cannot force a tribe to come out to the site. That's not a prerequisite to approval of a license issuance. With respect to the rest of the SEIS, these matters like groundwater, byproduct material, waste management, as you put earlier, they were the lay of the land, the standard format. The lay of the land is set up in what's section 3 of the supplemental EIS, and the impact analysis is in chapter 4. So that is pretty much it. And what I would like to say about ISR projects is they are handled, regulated, and developed pretty much, with limited exceptions, the same way. And that's the reason why the NRC staff was able to develop a generic or programmatic environmental impact statement, which they used to tier the supplemental EIS off of. And tiering, NRC staff said when they developed it, is an accepted CEQ approach to dealing with a programmatic environmental impact statement.
And so you don't see anything deficient about the primary generic one or the supplements in this case, given your experience, and you say this happens all the time?
No, ma'am, I see no defects. And you have to also take that there are two aspects to a license approval. One is the supplemental EIS. And then there is also an accompanying safety evaluation report that addresses the technical matters. That then there is the totality of the administrative record, which is known as the record of decision. And by case law, by commission case law, licensing boards can amend a license or an EIS by affirmative judicial decision. And the reason I'm saying this is it happened the same way in the NRDC versus NRC case involving Strata Energy. The board instituted a brand new license condition, which frankly, if you ask me, I think was a bit unprecedented. But they said you have to plug all the abandoned boreholes before you proceed. Now, the way ISR works, Your Honor, is they do what are called pump tests when a well field is fully installed. The pump tests are designed to detect whether there's communication between abandoned boreholes and the ore zone water. And every site that has ever been licensed in this country has multiple abandoned boreholes because you got to find the ore body and delineate it. So I would say, Your Honor, the short answer to your question is the record of decision is complete. I'd just like to offer one thought on the cultural resources. Very little has been mentioned about the programmatic agreement. And as Mr. Parsons said, the programmatic agreement was added as a condition. They added condition to it, which is fine. We don't, Power Tech has no argument with that. But the point is the programmatic agreement under 36 CFR Part 800 is by far the most stringent approach to site development monitoring of cultural resources. The Advisory Council on Historic Preservation, and this is at JA 898, signed a letter, and this was almost unprecedented. I'm not familiar with any other time they've ever done this, but they signed a letter to NRC that said, you have satisfied the reasonable and good faith standard under the NHPA. And that is very, very important. And then there is yet one more additional safeguard that Mr. Parsons has failed to allude to on cultural resources, which is there is a standard clause, condition, I'm sorry, Your Honor, a condition put in every single ISR license called an unanticipated discovery clause, which is if you are, say, hypothetically excavating some material to lay a foundation for a processing plant, or you're drilling a well and you find something at 9-10 feet down, the rule is you have to immediately stop what you're doing and get qualified experts out there to evaluate it, to find out whether there is mitigation available, such as fencing it off, which they did at the Church Rock site in New Mexico for hydro resources. That case was evaluated by the 10th Circuit. And then, but it doesn't preclude you from destroying a cultural resource if it's not significant. So, and I'm not saying that's something we want to do because we really don't. But I would say that that is an additional safeguard put in on cultural resources. Now, most importantly, on the programmatic agreement, we can forget about all the provisions associated with it for the time being. But it is, the tribe did not sign it. And typically in the case of programmatic agreements or memoranda of agreements under 36 CFR Part 800, tribes don't sign them. So, which is fine. But Mr. Parsons' client is allowed, once we start to develop the site, that the Oglala Sioux can just come out and say, look, we want to be part of the process. And they're free to do so. And I mean, it goes to show you that NRC, along with EPA in the state of South Dakota, this is a three-way regulation of a property that is by far the most environmentally benign form of mining in this country. So, Your Honors, I apologize. I've significantly gone over my time. If I may sum up or answer any other questions you have.
Judge Rao, Judge Jackson. All right, thank you, counsel.
Thank you, sir.
All right, counsel for petitioner, you were out of time, but we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. I appreciate that. I just want to address a couple of things with respect to Mr. Adler's argument on behalf of the agency. There was no bar to proceeding with conducting oral interviews. The tribe encouraged that. And in fact, 1502.22 or 21, there's some confusion just because the regs have been changed since. It was 22 when all relevant matters in this case occurred. So that's what we've been referring to. It's 21 now. Does require additional information to be, all existing information to be accounted for. And as was laid out in the record, there are multiple declarations from Lakota people who indicate that they have information about the site and would have been willing to provide that. It's not that the Oglala Sioux tribe government is the keeper of all cultural resources information of the Lakota people. It's that the statute, the National Historic Preservation Act, requires consultation with the tribe. So there's certainly information, additional information out there that NRC could have and should have acquired.
Parsons, I think the NRC's position was not that there might not be such information, but that seeking such information in individual interviews would upset the government to government relationship or consultation.
I don't think there's any basis for that anywhere in the record. The government to government or the consultation issues derived from the National Historic Preservation Act. What we're talking about is the National Environmental Policy Act, is the 1502.22 requirements. And as you see in Joint Appendix 1709 and forward, there are multitudes of people with relevant information who are ready, willing, and able to discuss with the agency. I just want to address Mr. Pugsley's reference to the Advisory Council on Historic Preservation letter and the programmatic agreement. Both of those documents were finalized in 2014 prior to the Atomic Safety Licensing Board finding that neither NHPA nor the National Environmental Policy Act had been complied with. So those do not somehow rehabilitate the statutory violations at this point. Those were well in the record prior. And in fact, if you look at the programmatic agreement, it is predicated. One of the prerequisites for that document is that it's a finding that there have been adequate cultural resource analysis or surveys conducted. And that was found to be not true, adjudicated, found to be not true by the board as affirmed.
Mr. Parsons, can you point us in the record to the place in which the tribe encouraged direct interviews without a site survey?
We did that in our briefing. Also, I think one of the best places to look are the letters that were exchanged between NRC and the tribe. The tribe's letter, again, at JA 1857, I think is a good example of the tribe explaining how it's been consistent throughout and how it's been trying to require the agencies to come through and participate with the tribe in developing the methodology.
And yet it appears, Mr. Parsons, my last question is, yet it appears that the board, in its very lengthy recitation of what happened according to it, and I'm talking about the final decision after the hearing, gosh, I don't even know where I am, JA 8 in the 800s and 900s, talks about the facts in a way that seems inconsistent with the inferences that you would have us draw from things like the letters. And I'm wondering what we as the appellate body, what we can do in terms of looking at the facts? Aren't we to some extent to give deference to what the board found were the facts about who cooperated, who didn't cooperate, whether it was reasonable or unreasonable to interview witnesses or the like, whether there was a valid methodology proposed by the staff? I mean, it seems like all of that is covered in this lengthy determination of the board that involves a lot of facts. And ordinarily we give deference to an agency in its determinations of fact, particularly after a lengthy evidentiary hearing.
Right. Thank you, Your Honor. I would say that the facts or any findings with respect to who was at fault for pulling back on the cultural resources surveys is largely irrelevant on the law. The law applies, it's the Nuclear Regulatory Commission's obligation to comply with the National Environmental Policy Act. If the commission felt like the tribe was not going to participate, then it had other avenues to pursue and was legally obligated to do so. It's the agency's responsibility to meaningfully consult with the tribe in good faith under the National Historic Preservation Act, and it's the agency's responsibility to comply with its environmental review responsibilities for cultural resources. And as we quoted in our briefs a couple times, the agency cannot push those obligations off onto third parties. And that's basically what's occurring in this case, is that the NRC is saying, well, if the tribe isn't playing the way we'd like them to play, then we don't have to comply with our statutory responsibilities. And that's just not what the law says. Again, we dispute that the tribe was somehow recalcitrant. I think those, in particular, those interactions in February and March of 2019 that I alluded to in the record at 1888, JA 1888 and 1857 do shed considerable light on that issue. So I would encourage a review of those interactions.
All right, thank you. We have your argument. We'll take the case under advisement.
This honorable court is now adjourned until Wednesday, November 10th at 9:30 a.m.